Hi, my name is Daniel Miller of Miller & Miller Law Group. Probate is the process of bringing a last will and testament to the surrogate's court and asking for them to prove its validity. Once the court declares that the will is valid, they issue something called letters testamentary to the executor. This allows the executor to step into the shoes of the decedent and handle their financial affairs. In order to probate a will, you need to give a copy of that will to the people that would inherit if there were no will. Those people have a right to object to the will. So for example, let's say I have no close family and my closest heirs are my nephews who I haven't spoken with in 20 years. In my will, I leave everything to my neighbor who's been my closest friend for 40 years. Even though I haven't spoken to my nephews in years, they would get a copy of my will and have the right to object to my will being offered for probate. An average uncontested probate takes approximately a year to close out the estate. I tell all my clients that probate is a three-phase process. The first phase is getting the executor appointed and having the courts issue letters testamentary. The second phase is for the executor to marshal the assets and pay the liability of the person that passed away. The final phase is to account to the beneficiaries and distribute the assets according to the last will and testament. Phase 1 is to have the executor appointed. This requires submitting the original will, death certificate, and accompanying documents to the surrogate's court. Gathering all the necessary documents to submit from all parties and having the court review the documents usually will take a few months. Once the surrogate's court declares the will to be valid, they issue letters testamentary to the executor. Once letters testamentary are issued, we move into phase 2 of the probate process. Once the court grant the executor letters testamentary, it's time for the executor to get to work. The executor's job is to marshal the assets and pay the liabilities of the estate. This step involves getting a tax ID number called an EIN number, setting up an estate bank account, transferring the person who passed away's assets to the estate account, possibly selling property, determining the liabilities of the decedent, and handling taxes. The most important step of being an executor is keeping detailed records. Every penny that was brought into the estate should be accounted for. Many executors make critical mistakes in this phase of the probate process. Miller & Miller Law Group is here to ensure that the executor is protected and fulfilling their duty to the beneficiaries listed in the will. The last step of an estate is everyone's favorite, distribution. After all the estate property has been marshaled and liabilities have been paid, the executor can begin the process of distribution according to the last will and testament. The executor should wait 7 months for any creditors to submit their claims to the estate. It also may be advisable for an executor to withhold some of the funds as a precaution in the event another claim was to surface against the estate. In this phase, the executor provides an accounting of all the work they did to the beneficiaries and the proposed distribution from the estate. If the beneficiary agrees, they sign a release and receipt, which releases the executor from liability by the beneficiary. Once all release and receipts are received, the executor distributes the funds. Miller & Miller Law Group PLLC is here to assist in all 3 phases of probate. For more information or to schedule a consultation, feel free to give us a call at 718-875-2191 or visit our website at www.nycelderlawyers.com.